2026. Both of those proceedings are in for.
And Your Honor, if I could address bond.
Ma'am.
It's come to my attention that Mr. Evans has contacted the victim's listed number from his PIN in the jail about 10 times, 48 attempts. The most recent completed call was on March 2nd, so at this point I'm going to ask for phone privileges and texting privileges to be revoked.
Your Honor, it's our information that
Right away, this hearing turns serious. The prosecutor claims the defendant contacted the alleged victim multiple times from jail, something that could be a direct violation of a no-contact order. In many courts, even one call could be enough to cause problems, but here we're talking about dozens of attempts.
he was making these calls in relation to DTE, his daughter, stepdaughter, Cormora Evans, informed him that the family's DTE Energy had been shut off, and he was making arrangements to have family member, his sister, Kathy Ann Evans, go over, pay the bill so that the services could be restored.
And it got cut back on.
And it was turned back on.
And Your Honor, I did want to note, in the one file I listened to, I did not mention of DTE. I also have concerns given that he had a large violation. He was out of custody, said he was going there to help pay bills. Is now in custody for this violation of the no contact order, was told not to contact her, and then was contacting her. At this point, it
Well,
times.
But my information,
I'm unclear. Why would the
stepdaughter called,
need to be contacted?
he was calling his stepdaughter, 313-756-0770,
But the
Cormora Evans.
stepdaughter, are you saying it's a landline?
It's
Or is it a cell phone?
cell phone. It's her cell phone.
Whose cell phone?
It's her cell phone.
Her being who?
The daughter.
But that's not the number that was called.
Now, the defense offers an explanation that changes the tone a bit. According to them, the defendant wasn't trying to contact the victim emotionally, was trying to fix a family emergency. The electricity had reportedly been shut off, and he was calling family members to arrange payment.
That is the number that is called, Your Honor, and that was the number that is listed for the victim in the police report. And from the conversation, I'm not sure.
Yeah, ain't no.
But, Your Honor, the stepdaughter informed him that they had $196 bill that was passed to services, electric services. I'm sorry, DTE was shut off, and the stepdaughter needed to
How
access.
many calls were there?
10 completed calls, 48 attempts that were not completed.
I hear what you're saying, but I don't know that it would take 2 calls to do that.
Well, they had to go back and forth because
Oh, what?
the stepdaughter had to contact his sister, Kathy Ann Evans, who lives in Toledo, to come up and make arrangements for the payment. Kathy Ann Evans is a sister, 440-619-9656. She's helping the family out while he's incarcerated so that they can eat.
I
Keep the-
struggle with that, but I'm just trying to. Why is there going to need to be 40 attempts and 10 completed calls to get this accomplished?
I can't speak to that. All I can speak to is the urgency in his mind to keep the family, the utilities. It's cold outside, Your Honor. They need gas for the stove.
It did get cut back on, too, Your Honor. I was just trying to do the right thing, make sure everything was right. Even being in here.
He's trying to save his job. Across the street, he's told he could still work at KFC. He saved money.
I get all of that. And I can appreciate it. And maybe if there had been 2 or 3 calls trying to get that arranged.
And this moment may have sealed the defendant's fate. The prosecutor says one call included emotional statements like, "You hurt me," and "I love you." If that's accurate, it suggests the calls weren't just about bills anymore. Courts are extremely strict.
One could do that, but was DTE mentioned in any of the calls?
I didn't get a chance to listen to all the calls, Your Honor. The most recent call I listened to was the one that occurred on 32, and that was mention of "you hurt me," "I love you," things like that.
Well, on today is the 9th. The DTE situation occurred around
Yeah.
last Monday, the 2nd, Your Honor.
Yeah, but that's not what he's talking about when he's on the phone in that call.
And there were calls
That
prior to
was
that 2 days.
that was a different thing.
And Your Honor, we've had situations where people have been charged and they don't pay the bills. They don't pay the phone bill. They don't pay the rent, and the complaining witness gets evicted. So we have the reverse here where he's trying to do the right thing. He has $500.
That were the entirety of the subject matter of the calls. Okay. That doesn't sound like that's the entirety of the subject matter of the call. Also, the number of the calls doesn't make any sense. And Ms. Zenda was saying that there are calls before that shutoff.
Your Honor, I have calls on January 4th,
Oh,
calls on January 6th, January 30th, February 1st, February 5th, February 2nd, February 23rd, March 2nd.
All payments,
those can't all be about the DT bill.
not just DTE, rents, everything. I'm sorry.
His rent is $1,586 a month, Your Honor. And he's depleted his savings down to $500 to try to keep the family afloat.
That's what I'm gonna do. If you want to bring it back by motion after you listen to all of the calls and are able to tell me that all of these calls, the subject matter of all of these calls involve bills or fights, we will be more than happy to do that. But just from the brief statement by the prosecutor in terms of what was said, it doesn't sound like that was what it was about.
And the judge makes the decision phone, and texting privileges revoke the court, leaves the door open for the defense to come back later with proof that the calls were strictly about family bills. But until then, the judge isn't taking any chances. It's a reminder that in court intentions don't matter as much as actions, especially when a no contact order is already in place.
And I'm not thinking these can't be mixed messages. If he's talking specifically about bills, he's talking specifically about bills. And that one can look at. But if he's talking about other things, particularly things that may relate to the case or try to play on the emotions of the victim or anything along those lines,
It's nothing like it.
it's
Let him talk.
Okay.
We have our chance.
I'm not going to be tolerant of that at all. So certainly I will hear it when you listen to them all. You can give me a fuller explanation as to the entire content of that. But at this time, I am going to order that the defendant's phone and texting privileges are revoked. Thank you. Court calls case Driscoll versus Maya Driscoll.
Haley said on behalf.
Ron Brown, praying on behalf of Mr. Driscoll. Your Honor, thank you for the opportunity. He was on the 1 o'clock docket, but I notified the court that he wanted to be heard in person. This is his chance to tell the court why he believes he's a good candidate for early discharge from probation.
Go ahead.
Is that correct?
Go ahead.
Well, Mr. Driscoll, state your name for the record.
I am Jeremiah Driscoll.
Thank you.
Here's Claire on behalf of Probation. Your Honor, Mr. Driscoll is before the court for a review hearing. He did submit a request for an early discharge from probation. Mr. Driscoll has completed 12 months of a 24-month term. He has completed the domestic violence program, paid all of his fees, and is reporting as directed. I did reach out to the victim. She is supportive of early release request. Probation was referred to the court as to the defendant's request.
Go ahead.
Good afternoon, Your Honor. I just want to say that I learned a lot over this year. I have no control over no situation that that's not me. Only thing I have control over is myself and no one else. And taking the time out, sometimes you gotta just separate yourself. Just like even on social media, you gotta separate yourself. You can't just be on there all the time. So, like I learned a lot this past year, and I feel like that I just want to move forward. keep making the best decisions.
So I'm not going to see you again.
No, only time I might see you is on the internet. That's it.
That was fair. I wasn't asking for that, but I got it. All right. And man, as I look through and I'm looking through the file, it is clear to me that, as you go through this, there was not one, and then she had gotten herself to the point where of the proceedings after the first one or second one, we were able to waive your appearance because you were doing so well.
Thank you.
Sure. So, since the victim is also supportive of this call, I'm going to grant your request. I'm going to discharge you from probation with
Thank you, Your Honor.
Your Honor, may I
Yeah.
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 What's your article?
My article. Okay.
And you are famous,
Oh, I'm not
Garner.
here doing my job. I just read. Okay. Absolutely.
I appreciate it.
Personal.
Thank you.
All right.
Thank you.
Take care.
Thank you. You too.
Well, court calls the case People versus Cat Robinson.
Yeah, at least that's all you have. You're on.
Ron Brown appearing on behalf of Mr. Robinson. Mr. Robinson, please state your name.
And Robinson.
Okay, this is that form I told you got to sign. Would you sign it for me? He's pleading as charged DV.
Plea form indicates that he's pleading to domestic violence and agency.
Yes, Your Honor.
Okay. All right. And sworn.
Raise your right hand. Solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, self together.
Yes.
State your name, please.
And Robinson. Sure, it is this court's understanding you're going to plead guilty to the charge of domestic violence. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that? In understanding that, do you still wish to plead guilty to that charge? How do you plead? Guilty. Now you understand by pleading guilty, you'll not have a trial of any kind. Signed an advice of rights form, correct? Any question about those rights? Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes. You understand you're giving up your right to appeal of right? Yes. Are you on probation or parole? Probation. Okay, we were on probation at the time of this offense? Yes? Yes. You understand that if your entrance of a plea of guilty in this case could be a violation. You understand that? You understand that that court then could sentence you to the maximum allowable under those other charges. You understand that? Yes. And understanding that, do you still wish to plead guilty to this charge? Has anybody promised you anything other than what's been stated here today on the record? It's really nothing to get you to plead. No. Anybody threaten you or coerce you? No. Doing this voluntarily? Yes. And of your own free will? Yes. And also because you believe that you are indeed guilty of this offense? On the date, January 14, 2026, location of 3000 Carpenter Road, Pittsfield Township, Washington County, State of Michigan. What'd you do on that day involving a Sharonda Stewart boss that makes you think that you're guilty? Hit her. Pardon? Hit her. Hit her? Pardon? Yes. All right. Who is she to you? My girlfriend. Girlfriend? And when you hit her, you did that intentionally? Pardon? Yeah. Well, you're shaking your head. I don't know. Did you hit her intentionally, or was it an accident? It was an accident, but Well, I hear that. Take it.
Okay. Can we set it for final settlement?
Absolutely. March. Jury final settlement conference in this matter will be set for April 10th, 2026